No, Judge, okay.
Speak English, sir.
Judge,
You like a translator, or do you speak well enough?
no, sir. I'm good.
All right, Mr. Octaviano, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
On April 11th, 2025, in Harris County, Texas, officers dispatched to a motor vehicle accident. Upon arrival, officers observed an individual standing on the passenger side of the motor vehicle talking to several McDonald's employees. The defendant confirmed to officers that he was driving the motor vehicle that was present. Another officer verified the defendant was driving by talking to witnesses on scene who stated that they observed the defendant exit the motor vehicle from the driver's seat and was the only occupant of the motor vehicle. Let's see. The accident occurred in the 10,100 block of Hammerly Boulevard, Houston, Texas. I'm just trying to get some details on the accident, Your Honor. Officers observed the defendants have trouble maintaining his balance, slurred speech, and drowsy eyes. Defendant initially stated he had nothing to drink, then stated he had Buchanan's, but not too much. Defendant stated he had eaten a torta, but could not remember where it was from.
The breath test shows 0.22, nearly triple the legal limit in Texas. At that level, your reflexes are shot, judgment's gone, and in court, this is practically a slam dunk for the prosecution. That not too much line is going to haunt him.
Standard field sobriety tests were conducted with the following results: 6 of 6 HGN, 7 of 8 walk and turn, 3 of 4 one-leg stand. DIC was read. The defendant consented to a breath test. 0.202 and 0.195 were the results.
Who said anything about driving? Did anyone?
So
I know you have the admission, but
right, and they said there was several witnesses that saw him. I'm checking now to get some details on that actual accident, Your Honor.
but you have witnesses that put him driving.
Yes, Your Honor.
Okay.
There was officers there that saw him.
I don't know if those are witnesses or named, Your Honor. I haven't had a chance to look at the offense report.
Well, I'll give you time. This is just a probable cause hearing, you know, if it goes, right. Mr. Octaviano, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, Your Honor.
Does he have a valid Texas license? You cannot drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, do not drive. That is also a condition of your bond. Do you
Yes, Your Honor.
understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance, but you must stay in touch with counsel and he'll tell you if and when you have to come back to court. For now, we'll have you go sign a reset. We'll have you get with pre-trial for your bond conditions, then you're free to go.
All right, thank you, Judge. And I've got one more arraignment, Judge, but I think we're waiting on DVD on that one.
Okay.
So.
Yeah. Good morning, Mr. Berryhill.
Good morning.
Sir, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 12th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a disturbance call and made contact with the complainant, who stated that the defendant came into his business and was upset that a check issued to him was not good. Upon arrival, the defendant became belligerent with law enforcement officers, and complainant stated he no longer wanted the defendant on his property due to his aggressiveness. Defendant stated he was not leaving until he got his money and was advised 3 times to leave. Defendant refused to leave each of those times and was detained by law enforcement officers.
Okay. Mr. Berryhill, I'm going to find that there's sufficient probable cause to go forward with your case. Do not go back to this place. Do not have contact with the complaining witness. Do you understand, sir? Yes or no?
Yes,
Okay. Do you have the ability to hire a lawyer?
yes, I would like to have a lawyer. I would like a reset, have your lawyer.
Sure. We'll give you a reset now. I'm going to have the state create bond conditions for you. Don't go back to this business. Don't have contact with the complaining witness. As long as you can comply, you and I will be best friends. Otherwise, it's just not going to go well. Do you understand? Don't pick up a new case. Don't become a danger to my city. That's all I'm asking you to do. You understand? So I'll have you sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it, and then you'll be free to go. Please. So can you file no contact, no going back?
Absolutely.
You are Mr. Saran. Sir, you're charged with criminal trespass. You're facing up to 6 months in jail. jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Law enforcement officers received a call for service where an individual stated that somebody was trying to break into her home. Officers observed the defendant matching the description given by a caller around in the area. Officers made contact with the defendant and he was identified by previous booking videos as well as his SPIN number. Officers made contact with the complainant on scene, who advised that the defendant was trying to break into her home. Complainant stated the defendant knocked on the front door, rang the doorbell, and looked through windows of the complainant's property. Complainant observed the defendant enter her backyard, stand on top of a shed to look into windows, and attempt to pull on a door handle to open the door.
And it's only a trespass.
Complainant has surveillance footage of the defendant on her property. Officers searched the defendant and found an unused pipe that officers' training experience indicates it was used for meth. Defendant stated he was a frequent user of methamphetamines. Defendant further stated that during an interview with officers that he was looking for items of value at the above residence in order to obtain money for drugs since he was currently out of money. I think that the reason it wasn't charged as a bird cab is because he wasn't actually able to make entry into the residence.
Mr. Saran,
Yes, sir.
since 2023, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and now 11 in a matter of 14 months. If I find that you're using any kind of dope, I'm going to take care of it in a way that you're really not going to like it. I'm sending you now for a drug and alcohol test because I want to know what, if anything, is in your system. You're ordered not to use anything. And if I find that you do, and if I find that you become a danger to my community, I will grow a horn and tails. Do you understand?
Yes, sir.
I'm putting a GPS monitor on you so I know where you are at all times, and I don't want you out in the middle of the night.
Yes, sir.
It's time for you to stop using. I'm giving you now the opportunity to do it on your own. If you're incapable of doing it your way, then we're going to do it my way. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
Please appoint him a lawyer. I'm sending him now for a drug test. You were to go test, and you were to come right back. I just want to know what, if anything, is in your system.
Yes, sir.
If you fail to test, if you fail to come back, I will issue a warrant. No more PR bonds. Do you understand?
Yes, sir.
Take a seat for me. All right. Good morning, Mr. Graham.
Good morning, sir.
Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
On April 13th, 2025, law enforcement officers observed a vehicle with an expired registration and conducted a traffic stop. Upon contact with the defendant, law enforcement officers observed the odor of marijuana coming from the vehicle. Probable cause search was conducted of the vehicle and the defendant. Defendant stated he was in possession of marijuana, which was found to be 0.524 ounces of marijuana in his pocket. Defendant also stated that he had a handgun in the center console. The handgun was recovered from the vehicle. All right.
Can you run his license?
Absolutely, Your Honor.
Mr. Graham, I'm going to find that there's probable cause to go forward with the case. While this case is open, I'm ordering you not to be in possession of weapons. Do you understand?
Yes, sir.
You have the ability to hire a lawyer.
Yes, sir.
Okay, we are going to give you time, so I will have you go to Victoria, sign a reset. We are going to create bond conditions. License?
It's eligible, Your Honor.
Okay, you're not allowed to drive unless you have a license and liability insurance in your name, and that's part of your bond conditions as well. So we'll have you sign a reset, we'll have you go to the box while we get your bond conditions created, we'll have you sign it, and then you'll be free to go. All right?
Sir, thank you.
Please. Thanks, man. Sir, you're charged with racing on a highway. You're facing up to a year in jail. And I'm sorry, you're facing up to 180 days in jail and or a $2,000 fine.
Law enforcement officers observed a large group of performance cars gathered at a location and then saw two of the vehicles line up side by side and accelerate to approximately 100 miles per hour. Law enforcement officers recorded the events, and another law enforcement officer initiated a traffic stop where they made contact with the defendant, who was the driver of one of the vehicles that had took place in this outpacing contest. Defendant admitted to being in the races and stated that he never got out of his vehicle while he was at the race.
Do you have, do we have a co-defendant in this case?
They're checking now, Your Honor.
And number one, number two, does he have a license?
I can check, Your Honor. So the co-defendant's not linked in our system. I don't know if they just were able to stop that one.
Right.
But I'm running his license now, Your Honor.
Mr. Barber, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to participate in these types of events again. If I find that you do, first thing I will do is I will put you in jail. And the next thing is I will take away your privilege to drive while this case is open. Do you understand?
Yes, sir.
You're not to participate in any street takeovers, racing, donuts, reckless driving, anything of this nature.
Yes, sir. Can I say one thing?
Do not, don't. Just the only other thing I'm going to caution you is you are not allowed to drive unless you have valid liability insurance in your name as well. If you don't have car insurance in your name, you're not allowed to drive, and that's a bond condition as well. If I find that you do without, I will revoke the bond and put you in jail. You understand?
Yes, sir.
Do you have the ability to hire a lawyer, sir?
Oh, yes, sir.
Okay, we're going to give you time. I will have you go to Victoria, sign a reset. We will have you go into the jury box while we get your bond conditions ready. We'll have you sign it, and after that, you'll be free to go.
Yes, sir.
Please. You were charged with assault of a family member. You are facing up
Puede recibir hasta
jail and or a
un año de cárcel,
$4,000
hasta
fine.
4,000 dicen.
Law enforcement
Los
officers
oficiales
were dispatched to a disturbance.
fueron a
Upon making
al llegar
scene,
a la cena,
they spoke with
se hablaron
the 10-year-old daughter of the
la hija
complainant,
de 10 años de la fijante,
who stated
que
that her
dijo que
mom
su madre
was hit in the face
le
by her dad.
pegaron en la cara por su padre.
The complainant
La
stated
fijante
that she was
dijo
struck
que ella
in the head
en la cabeza
at least 3 times.
3 veces.
Domestic violence cases hit different. Not only is there an alleged physical assault, but a child is a direct witness. That skyrockets the emotional impact for a jury and adds pressure for a tougher sentence. And the fact he barricaded himself, that screams consciousness of guilt.
With a closed
Con un
fist
puño cerrado.
while also being
Ellos
kicked
también patalearon
on the side of her
en
torso.
la- su cuerpo.
While this was going on,
Mientras que esto estaba
the
ocurriendo,
defendant
La
had barricaded
comunidad.
himself
se vio encerrado
in the children's bedroom
en el cuarto de los niños
of the residence.
de la residencia.
Um, Complainant also stated
También dijo de que
that she was dragged by her hair.
la sujeron de su cabello.
The 10-year-old
La
child
niña de 10 años
observed all of this.
observó todo.
The victim, the complainant
Esa
stated
gente dijo de que
that she felt
ella
pain
sintió dolor
during this,
durante
but was unable to provide a
y
number.
se pudo dar
on a scale of 1 to 10.
numeración a 1 a 10.
Yes, Your Honor.
Estaba involucrado algo. Dice sí, sí.
10-year-old witness did advise that the
Niña de
defendants
10 años
had been
dijo
drinking
de
some
que
kind
había
of
bebido
alcohol.
un tipo de alcohol.
Mr. Mata Rojas, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail.
Te voy a encarcelar.
I want you to know that I will protect every person in my county at all costs. I don't care who you are. I don't care why you're here, how you're here. If you're not in this country with permission and you go to jail and immigration finds you, they will possibly put an immigration detainer on you and you will be stuck like Chuck in custody until this case is over with.
Hasta que se acabe el caso.
Do you
¿Tú
understand?
entiendes? Contesta.
Sí,
You're
Yes.
not to have contact with the complaining witness in this case. You're not to be in possession of weapons, and I don't want you to go within 200 feet of where she lives or where she works.
Judge,
Su señoría,
it seems like the
Parece
CW is
que quiere
going
que
to
gente
want to protective order. I've instructed them if they do, we'll have to come to court and you'll have to see and hear from her if you
I
consider
think
that.
the allegations are,
las
you know,
alegaciones son.
There might be some self-defense allegations as well.
I get it, but all I know is that at this time, Mr. Mata Rojas, I don't want you to have contact with the complaining witness in this case. I don't care if she comes to you. I don't care if Jesus comes down and says we're having a party and she's there and they want you there. Don't have contact with the complaining witness. Do you
¿Lo
understand?
entiende?
Test.
Yes.
Judge, if she, after like 30 days, if she wants the protective order removed, would you be open to if she comes to court?
We'll keep an open mind. I don't know.
Yes, sir.
All I want to know is that, number one, he's not using, and number two, that she's protected, and that she feels that she's not in danger.
Absolutely,
So, I mean, come back in a while and then we can talk to her and we'll see.
absolutely.
But until that,
Is his appearance waived? I know your rule, but I just wanted to hear from the court.
Mr. Mata, you have a lawyer. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Martinez, and he will tell you if and when you have to come back to court. If Mr. Martinez tells me he can't get a hold of you because you're ducking, dodging phone calls, text messages, or you pick up a new case, I will revoke your bond and put you in jail. Do you understand?
Yes.
So we have a MOAP that has been already issued in this case, right?
Yes,
Yes,
sir.
sir.
There's a protective order that has been issued in this case. I would get to know it. If you do something to violate this protective order, the state can and probably will file a violation of a protective order. And that is one of the worst misdemeanor cases that you can pick up. For now, we'll have you go to Victoria, sign a reset. You will then get with pretrial for your bond conditions, and after that, you'll be free to go. Thanks, Herman. Thanks for being patient. Good morning, Mr. Cummings.
Good morning, Judge.
So you're charged with deadly conduct. You're facing up to a year in jail and a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 11th, 2025, officers were dispatched to a family disturbance call. Officers arrived and met with the complainant, who was ID'd by her Texas driver's license. Complainant identified the defendant by name and date of birth. The complainant stated that an argument occurred between her and the defendant. The complainant stated the defendant grabbed his handgun and held it in his hand as he became angrier. Complainant left the apartment due to fear.
This moment is chilling. In legal terms, pointing a gun and putting someone in fear of serious harm can be enough for a deadly conduct charge, even without pulling the trigger. But the defense could argue he never directly threatened anyone verbally. That fine line might decide the outcome.
Complainant returned to the department and contacted the Harris County Sheriff's Office to report the incident. Officers made contact with the defendant. When officers approached the defendant, he stated, quote, "I'm not talking and I don't want to answer any questions." Defendant began to gather his things and grabbed a handgun and placed it in a fanny pack. Officers drew their guns on the defendant, and the defendant stated, "Are y'all going to shoot me? Shoot me then." Defendant complied with verbal commands and was detained.
Is the brandishing of a firearm enough for a deadly conduct? Because does he do anything affirmative? I guess.
So, yeah, and that's, I mean, I would, we're at a PC hearing, Your Honor, I'd have to do some case law research, but I can see how it's charged is brandishing the handgun, putting the complainant in imminent fear of serious bodily injury. I think the reason it probably wasn't terroristic threats because there was no word said.
Right.
It was just grabbing of the handgun.
Let's do this, Mr. Cummings. I'm going to appoint you a lawyer today so we can figure out, because, you know, we get down and dirty with every case because I want to make sure if I find probable cause, there actually is probable cause. So let's do this. I'm going to appoint you a lawyer today and I'll have him talk to you and then we'll revisit this PC hearing momentarily. Okay. Just take a seat, but don't leave. All right.
Yes, sir.
And we'll have you talk to someone here momentarily. Okay. Good morning, Mr. Martinez. Sir, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 12, 2025, officers observed a motor vehicle failed to signal a lane change. Officers also observed the motor vehicle's registration had expired in 2022. There was also unconfirmed insurance. Traffic stop was conducted. Defendant was identified by his Texas ID card. Defendant stated he did not have a driver's license nor proof of financial responsibility. Officers learned the defendant was not an eligible driver due to a license suspension back in February of 2024. Officers learned the defendant had 5 prior convictions for failure to obtain liability insurance on his license. Officers asked the defendant if he was aware of his driver's license was suspended, and he advised he was. However, he did not know how it was suspended, saying he was working on his SR-22 and reinstating his driver's license.
Martinez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive. I don't care what you have to do in this life. I don't care if there's someone having a heart attack and you have to go save them. There's a burning building and you have to save 50 kittens. I don't care. If you don't have a license and liability insurance, you're not allowed to drive. This is an affidavit that you're going to be signing with me. And if I find that you do, every single time you drive, it's a contemptible action, punishable by up to 6 months jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
If you want to drive, go get a license, get liability insurance, and I will be doing backflips. So happy I will be to take this off. But if I find that you do, it's really not going to go well for you. Do you understand this?
sir.
You have the ability to hire a lawyer. No. I can have you fill an application. I'll take a look to see whether you qualify. Deputy Miranda will give you an application. I'm going to have you come swear to us that you're not going to drive. I'll get you to Victoria sign a reset, and then we'll have you take a seat. Please.
Your Honor, you can file law conditions for it.
Yeah. Yeah. With both. No driving and then no without insurance as well. Ma'am, you're charged with 2 cases. You're charged with criminal mischief, and you're also charged with interference with the emergency request for assistance. On the criminal mischief, you're facing up to 6 months in jail and a $2,000 fine. And on the interference case, you're facing up to a year in jail and or a $4,000 fine. I also see she has an open warrant.
Yes, Your Honor. I see that as well.
You also are charged with, I guess, the following day, you picked up a terroristic threat. On that case, you're facing up to 6 months in jail and or a $2,000 fine. First, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Let's do probable cause and then we'll.
On April 13th, 2025, officers were dispatched to a disturbance. Dispatch stated that the defendant knocked the complainant's phone out of her hand and then left the location. Officers made contact with the female matching the description given by dispatch. The female stated that she was the victim, but she was not talking without a lawyer. Defendant gave name and date of birth, but would not provide an ID card. Defendant was detained and taken back to the incident location. Complainant stated she reported a criminal mischief on the defendant the day prior. Complainant advised to dispatch that he would later call back and report the incident, which he received video of the incident proving that the defendant had damaged his vehicle. Complainant advised today he went to the store, and when he returned, the defendant was on his porch. Complainant asked the defendant, "What are you doing here?" After you broke my window of the vehicle of my vehicle. Complainant advised he told the defendant just to sit there while he called police. Defendant then left, but returned while he was on the phone with dispatch. Defendant knocked the phone out of his hand and caused damage to the phone. The value of the phone was $300.
And what about the terroristic?
So the terroristic threat, Your Honor, and this is the same complainant. On April 15th, officers were dispatched to a telephone harassment. Upon arrival, officers spoke with the complainant. Complainant stated that he had received a phone call from the defendant via a Google phone number threatening to shoot up her home. Complainant stated she was confident the caller was the defendant and expressed her desire to pursue criminal charges. Further investigation revealed that the defendant had been arrested at the same location on April 13th for interference with an emergency call and mischief. She was out on bond for that incident.
Should be given conditions not to go back.
Let me check your.
Ms. McKnight, I'm going to find that there's probable cause to go forward with the case. I don't want you to have contact with this person.
It's not for them. I'm hurting about that person.
I don't want you to have contact with this person. Do you understand? Are you sure you understand?
Yes, sir.
Okay, I don't want you to go where this person lives. If you do, it's not going to go well. I will revoke your bond, put you in jail. Do you understand?
Yes, sir. I have evidence for all that.
And I'm going to give you a lawyer today. I know that there's 2 sides to the story. You can give your side of the story you can give your side of the story to the lawyer, but I don't want you to have contact with this person. That's it. Do you understand?
So when it comes down to the child, do I have to come back to court just to get in contact with him?
I don't want you to go to his house.
No, I'm talking about, do I have to come to court so I get in contact with him because we have a child?
We'll figure that out. Let me get you the lawyer and then we'll figure that out. But just don't go to the person's house. Don't have contact with him. Don't call him. Don't use anybody else's phone to contact him. It's not going to go well. You need to understand that if I revoke your bond in this case and I set them at $5,000 to $10,000 and you don't have anyone to post those bonds, you will be stuck in there until these cases are over. Do you understand?
Yeah.
Okay. Deputy Miranda, you mind? You know what? Don't even worry about it. I'm going to appoint your lawyer today. I'm going to have you sign a reset with Victoria, and then we'll have you take a seat in the jury box while I find your lawyer. Don't leave until you sign our bond conditions.
In your honor,
Okay.
I want to wait